Are we recording? Just started. Okay. All right, guys. Thank you for coming. Once again, my name is Jeff Kim. I'm a broker associate here at Colliers. I specialize in multifamily investments. We like to put on events like this for clients, for the public, because I think it's very valuable information. It's very important information. It's generally information you can't get for free. It usually costs some money. Right? Attorneys, as we know, for good or for bad, notorious, they get paid very well per hour. So we really appreciate Paul Franco coming to share his knowledge, share some information with us. We met a couple years back through a mutual contact. Paul has helped me on a few deals now, educating clients on setting up trusts, setting up entities, organizing and estate planning so that they can prepare to sell and just doing it the right way that is the most tax favorable, I guess you could say. So anyways, I can kind of give you guys some basics on it, but we're here to hear from the expert. We're going to record the content. The content should be on the JKRE group. That's our team name, JKRE Investment Group. Should be on the JKRE Investment Group YouTube channel. So if there's any content you may have missed, you can always catch it there. But without further ado, let me welcome Paul Franco.
Thank you, Jeff. Good morning again, or good afternoon, I guess is the case. And thanks for coming and having me. I'm going to be talking today specifically about estate planning and what that is, what's that about, and something for all of you to consider and give you information and knowledge of how it may either help in your own lives eventually or now, and maybe others that that you might want to pass on. Briefly, a little background about myself. I am three things. I am a business attorney. I set up corporations, LLCs. I represent a variety of businesses, everything from your mom and pop Subway sandwich guys to construction companies to physicians to insurance companies to everything in between. I'm a very heavy real estate attorney of all kinds, residential, commercial, agriculture, industrial. I set up LLCs for them and do a lot of real estate transactions of every kind. Can be selling a house one minute, a vineyard the next, commercial building. And then the other part, which is what I'm going to be speaking to you about today, is heavy estate planning and probate. And with that, I think the place I would start is that it's kind of an either or when it comes to estate planning or probate. Today's conversation is really geared towards trying to impart on you the notion of having your affairs in order, because the estate planning part is getting your affairs in order and having your destiny planned, your wishes carried out when your time comes of death or short of death. And if you don't do that, then you go to the other door, which is probate, and I'm going to be talking about what that involves. And you'll see at the end of this the differences between the two and why I'm promoting for all of you the concept of estate planning and trust and that sort of thing as the better option to doing nothing, and you're having your estates and your matters dealt with through a probate. So behind me, as you'll see, there's estate planning, and that is a comprehensive notion, meaning that in my practice we have people that come to see me and they don't know what they need, they don't know what they don't know, and they may be dealing with something on a particular basis at that moment. And I have someone that may say, hey, my mom needs a will. Hey, my accountant said I should get a trust. Somebody needs a power of attorney for something they're doing in that moment. And these are all singular components of what people need overall, which again is estate planning. Estate planning is everything. I often say that you would never insure your home but not insure your cars, right? You wouldn't pick and choose what you need, and sometimes people do that. Sometimes people do nothing. one of the things that we do know, or you ought to know, is that we cannot control our destiny. We all have the same chances when we leave our driveway in our home every day, you know, and oftentimes people will think of people that are older and have health problems. They need that stuff. Not me. I'm young. I'm in good health. I'm vibrant. I'm all those things. You know, once again, you get out on that street, you get on the 99. I saw something this morning. Central Valley leads the state or the country or whatever it is, and DUI deaths. You know, that there's a lot of risks out there, and I've seen healthy 35-year-olds die of a heart aneurysm out of nowhere, and nobody ever would have thought that. So if you think that you've got all the time in the world, maybe you do, but you don't forever. We all are going to succumb at some point, and we don't know when that's going to be. And so it's a matter, will you be prepared? And so sometimes the question is, because people don't know, do I need a will? Do I need a trust? Well, I'm going to tell you what you need, and you need both. That's that short answer to that. So let me start with this, when I talk about estate planning, there are different components that everyone needs, and that is everyone needs a will, regardless of what your assets are. Everyone needs a power of attorney for financial. Everyone needs a healthcare directive. For those people who have gross assets of $200,000 or more, you're a trust candidate. You also need a trust. And so I think that's where we're going to start. So what is a trust? A trust is first of all, it's a document. It's an agreement that's made between you and yourself. There's the one party that's called the trustor. They are the maker, the person who is making the trust, sometimes referred to as a grantor or a settler. And the other part is the trustee, the person who manages and carries out the wishes and duties under a trust. And so when you make a trust, you are both of those things. You're the trustor and the trustee. And a trust is, if you think about it conceptually as like a basket, you want to put your more valuable assets, your more significantly valued assets into the trust. And so that trust, that sort of basket, when you die, passes and it avoids probate. The purpose of a trust, the trust we're talking about here is a revocable trust. Let's be clear about that. A revocable living trust. A trust that's made during your lifetime. That's what the term living means, as opposed to the old days. They used to make it as part of a will. It would be born from a will, and that would be called a testamentary trust. We don't like to do that anymore. That's an old school sort of a thing, because that results in a probate, which is what we now modernly want to avoid entirely, okay? And so what it's not is, it's not an asset protection vehicle. Some people say, so if I do a trust, this will protect me from creditors. Not this trust. That's not what it's intended for. Or it will have a bunch of tax planning goodies in there, lots of things that will lower my taxes. No, not this trust. That's not what it's for. This trust is solely to avoid probate. What is probate? Probate is a court administration of one's estate when they die. And so if you don't have a trust and you have gross assets over $200,000 as of last year, and as you can imagine, that doesn't take much to get you over that. If you own a home, you are a probate candidate. And really everything about a probate is generally considered negative. It's very expensive, exponentially more expensive than doing something like preparing a trust. It takes quite a bit of time. On average, probate's about 12 months, 12 to 18 months, depending on how quickly you can move that process. What that means is nobody gets their money until that's done. So if you're leaving money to heirs, they're not going to get that money in a probate for 12 to 18 months. And if that's not bad enough, if you leave children, if you leave disabled people, if you leave people that really need that money, they're going to have to wait a long period of time. The probate process, generally speaking, is a very rigorous, procedural process. There's lots of things that have to be done. There's lots of things that you may not want to agree with, selling the property, how it gets sold, doing things you don't want to do. Why does the court make me do this? Why do I have to do that? Well, it's because this is the default and this is the program and this is the way it works. And finally, it's all public. Some people don't, it's not a bother, but for other people they have privacy concerns and they don't want the world knowing what they died with, who it went to, and if there was any squabbles or anything along the line in that. And all that's public record if that matters to you. Going back to the cost, the cost is extensive, as I mentioned, and the attorney's fees alone are called statutory attorney's fees. They're based on a statute. I mean, it says, the statute says what attorneys are to be paid, and it's a scale, and it goes like this. It's 4% of the assets on the first $100,000, that's $4,000. 3% on the second $100,000, that's $3,000. And then 2% on the next $800,000 up to $1 million. So on a $1 million gross estate, which we all know $1 million isn't what $1 million used to be. It's not that much as when we were young. We were like, $1 million, if I had $1 million, I'll be rich. Now you're just getting by. And so if we take $1 million estate and we add that up, we take 4,000 and 3,000, that's 7, and 16,000, that's $23,000 in attorney's fees. And then there's about $3,000 in court costs, filing fees, publication fees, and if there's a bond, that's even more than that. What's more, the person who serves as the executor or the administrator in a probate is going to be entitled to the same amount as the attorney, so another $23,000. So if you do the math there, we've got $56,000 or $46,000 and another $3,000. Eventually, you're about $50,000. Well, I can tell you to do a trust, it's not $50,000. So that's reason enough. The cost, again, a year or more until anybody gets their money. The rigorous hurdles, procedural hurdles in a probate proceeding, and the lack of privacy and public nature of it too. And so with all of that in mind, people say, well, I don't want that. How do I avoid that? It's a trust. The revocable living trust that I'm talking about. And this is a trust that can be revoked, meaning terminated, or it can be amended during your lifetime. When you die, it becomes irrevocable. This is not generally an irrevocable trust from the outset. Those have special purposes. Those are for things like people who are disabled or part of a someone with wealth planning who have gifting programs, and there's irrevocable trusts that are used. We don't use irrevocable trusts just sparingly. Those are for very special occasions. So this is a revocable trust. And within this trust, we can do a lot of things. We can provide for the details, the provisions of, number one, where our assets are going to go, to whom they're going to go to. We can have special provisions in there as far as contingencies. I give this to my children. Well, what if one of my children passes? Should their share go to their children, or should it go to my other children? It's a choice. Most people do to their children. How about an age restriction? What is an appropriate age for young people to receive a significant amount of money? Well, I can tell you from my perspective, for what it's worth, 90-something% of all my clients feel 25 years is an appropriate age. We have some that are a little stricter and will go with 30. We have some that are a little more liberal and will go 21. And a funny number that's been coming about recently is 28. And you know why it's 28? Husband wants 25 and wife wants 30. 28's the negotiated middle. So we actually have quite a bit of 28. So that's an example of something that you can do within a trust. You can also provide that for some people, maybe their amount is held in trust, and beyond that, for instance, if maybe somebody has a gambling problem, somebody has drug and alcohol problems, somebody has mental health problems, disabilities, maybe there's something called a special needs trust within the trust that we can do so that if they're receiving public assistance, Social Security disability, things like that, they can't have assets, those people. Otherwise, it will spoil, it'll terminate their public assistance. So if it is their share is held in trust under a special needs trust, that allows them to have money for in a supplemental way to the primary assistance that they're getting, public benefits that they're getting, without spoiling that. And so that's something that's special that can be done. There's something that's special could be done. Take, for instance, some of our farming clients. We have some farming clients, as you can imagine, and people want the farm to continue to be farmed and that sort of thing. But let's say you got a couple brothers and a sister. Sister doesn't farm, or one of the brothers doesn't farm, but one brother does farm. We could do something like we could leave an option for that one brother to buy out the other siblings, and he can continue to farm. Or we can make it in sort of in trust and have that one brother manage and continue to farm for the benefit of the other siblings. Things like that can be done. Or people can swap within that. You know, they've got however a couple $1 million. Well, I give this child this house, and I give this child that house, and I give this child who already has a house, I give them the cash equivalent. You see what I mean? There's different things that can be done, and for a lot of people, it's maybe not terribly exotic. It's just to my kids equally. And it's just that simple, and let them figure it out. Let them horse trade, if you will, or maybe they liquidate it all and they just split the money, and that's the way it goes. But that's what the things that can happen in a trust. You're able to appoint the trustees. So you'll be the trustee during your lifetime, and then you have successor trustees. Who will be the first trustee? And if that person can't serve, who would serve after them? And maybe there's considerations about who those trustees are. For instance, you have a couple sons, they don't get along, they fight, they have a history of not getting along. Probably not a good idea to make them co-trustees. Maybe what we do is we pick one as the first and then a backup as the second, or maybe the opposite. Maybe your children get along famously. They're best of friends. Let's make them both co-trustees, or the three of them all co-trustees, and let them all have a say and be involved and do that. So lots of things that can be done. And when we talk about the avoidance of probate, just so you know, the trust is the best way. It's the most meaningful way to avoid probate. There are technically other ways to avoid probate. A transfer that goes by way of a beneficiary designation, that's a a non-probate transfer. A joint tenancy, having property held in joint tenancy, that's a non-probate transfer, but they're just not preferred compared to the trust. They're clumsy. Take a beneficiary designation. Where on there can you say to be held in trust until they're 25? What if they're minors? Then it's going to go into a blocked account, or you have to get a guardianship until they turn 18, can't use the money, and then it gets dumped on them when they're 18. That's a terrible option. Or a joint tenancy. Well, you know, I'll just add my kids to it, and we'll all have the property together, and then when I die, it'll go to them by joint tenancy, and that'll be a non-probate transfer. Well, that was all great and well till that kid of yours got the tax lien. Wait a minute, why is there a tax lien on my property? Because you put your kid on it. Or here's a good one, a more popular one even. My kid has a spousal support order that he's running from. And the county's trying to get child support, and now they've put liens on my property, or they've pulled money in a line of credit and this and that. Well, you know, it wasn't the best option. Just because it's an option doesn't mean it's the best option. So it comes us back to the trust, where you can do all these sorts of things. You're the only owner until you die, and that is the preferred method. So the trust is one component, albeit maybe arguably one of the most beneficial components of estate planning. People will say, so if I have a trust, I don't need a will. Not true. You still need a will. This will is called a pour-over will, and it works with this trust. It specifically refers to the trust. It names this trust. And what a will is going to do differently from the trust is it's going to transfer all of your smaller, lesser significantly valued assets, your household furniture, furnishings, depreciating vehicles, your spoons, knives, and forks. If you have children that are minors, it's going to have guardianship provisions. Who's going to take care of my child if they're a minor? Different from the trustee who's going to provide income and support for that child during their lifetime, but who's going to actually take care of them? And we can name alternatives. This person, if not this person, then this person. So those are important things. The last thing that it was going to have is something called a pour-over provision, which makes it a pour-over will. And when I'd say that it refers to the trust, what it says is everything else goes to the trust. There are many occasions, it's more common than you think, where something gets left out of a trust. And there's many ways that it can get left out of a trust. A property can get left out of a trust by way of a refinance, a piece of real property. It gets taken out of the trust and it gets left out, and next thing you know, it's looking at a probate. Or it could be somewhere where after the trust was done, somebody bought a property or acquired an asset and never connected it or put it into the trust, and therefore it got left out. And then let's say that under the trust, you're doing something special, like I'm giving it to certain kids, I'm excluding others, or I'm including grandchildren, or whatever you're doing. If you don't have a will or a trust, then your assets will go by what's called intestate succession. Intestate succession is a statute in law that says your lineage, your descendants and your heirs, and where your property will go to. And it generally follows the bloodline. Goes to spouses, goes to children, goes to parents if no children, and so on and so forth. Well, what if you didn't want it to go that way? If it gets left out, then it's going to go that way. But with a pour-over will, catches it and pours it back into the trust where it belongs and where it will go. So that's one of the benefits of the will. And you would still need a probate, but at least it would put it in the trust where it goes, and your intents will be carried out. So that's the will. Again, still need that as well. We still need powers of attorney for financial. We don't always die. We may be incapacitated. As you can imagine, you could get into a car accident, you could go into a coma, you could have a stroke. There are different things that could happen to you, and unfortunately, life goes on. Bills still need to be paid, right? That's the reality of it. And who is going to deal with that stuff? We've had a lot of occasions, I don't know what it is, but people will have a stroke or something in the middle of an escrow. They're selling a property. Well, what happens? Well, if you have a power of attorney and you appoint persons, those persons have the legal ability to step in and sign all of those escrow documents, including the deed, and finish that off for you. Or you're sitting in a hospital and you're not working and money is needed to pay bills and do things. Who's going to get into an account to get money to pay those bills and that sort of thing? And so that's what the power of attorney for financial is. For you all here, which look like able-bodied people who are in good mental capacity and that sort of thing, you don't need anybody to have power over you now. You only need it if and when, if ever, there's an incapacity. So the type of power of attorney that I'm talking about is what I call, or we call, a springing power of attorney. It means it's dormant and will never become effective unless there is an incapacity that the powers spring from. Now, there are powers of attorney that are called general powers of attorney that are effective and active right now. Those are more intended for, let's say you have an older person, a mother or something like that, that's elderly and you're taking full care of them and that sort of thing. Those are the ones that need probably a power of attorney that's active now so people can act on their behalves now. But you all don't need that. You need what is a springing power. And what if you didn't have that? We know if you didn't have a trust, you'd have to go to probate. But if you don't have a power of attorney, what would happen then? One would have to get a conservatorship. And a conservatorship is another big behemoth legal proceeding in the probate court to have somebody appointed to be able to do what that power of attorney could have done if you just had one, that you didn't have this 4 or 5 page document, 6 page document. And it's also very expensive. It's not quick to get. It's another big legal proceeding. And the idea of all this here is, like I mentioned, having your affairs in order, not having to rely on the default of our state, our government, and things like probates and conservatorships. So that's what that does. And the last document that is needed in this comprehensive estate planning is a healthcare directive. It allows you to appoint persons to make healthcare decisions on your behalf if you're unable. So you can imagine if you got into a car accident and you're going into a hospital, emergency room, you're unconscious, right? You're incapacitated. Who's going to make those decisions about that procedure that the doctors are saying needs to be done? Your leg needs to be amputated. Who's going to make that decision? It would include up to end-of-life decisions. Who's going to make that decision when you're unable to speak on your own behalf? This allows you to appoint those persons. And then within that healthcare directive, you can provide your wishes as to how you feel about artificial life, organ donation, after death. Do I want to be cremated? Do I want to be buried at a certain cemetery? You can name your primary care physician so that if your doctors needed to know who that was to get a little history, what was this person came in with this cardiovascular problem? What's their history? Was this something that their primary care physician was aware of and had been treating them, or is this something that's just a new onset? That sort of thing. You know, I had an interesting thing. Once in my career, I had a client that came to see me from Merced and had a 92-year-old father who was in Mercy Hospital in Merced, and his sister was the first named agent on the healthcare directive. He was the second. And the father was in and out of the hospital. He was just an old man who was aging and dying of natural causes. He had gone in, got some pneumonia, and they had him on life support. And they had him on artificial nutrition. They had him on artificial respiration, and whatever else artificial that he had a catheter, all of those things. Dad was a war veteran. I don't remember which war, but he was a veteran, a proud man who had put in his health care directive he did not want to be kept on artificial life support if it was a permanent, irreversible condition. And always spoke to his son, I never want to be kept like that. Well, the daughter, for whatever reason, just could not make the decision to allow him to go, or I don't think she had malintent, but I just think she just couldn't do it. And the brother was imploring her. So I was hired. I went into Superior Court in Merced, and I got an order to terminate life support. My client took it over to Mercy, and believe it or not, Mercy was in favor of that. A lot of people will tell you, oh, the hospitals just want to keep you alive as long as they can. No, they don't. It's not true. They want people to go when their time is to go, and they would rather turn these beds and turn these emergency rooms. They have no interest in running up a bill. They really don't. That's a fallacy. So they were in favor of this. So he took the order over to the hospital. Pursuant to the order, they pulled the life support. And by the way, the biggest problem was because he was old and 92, he had lost all of the elasticity in his lungs. He couldn't breathe on his own. They removed it and he died in about 2 hours. And, you know, I'll be honest with you, it's the only time I'd ever done something like that. Felt a little odd. I just had a man killed, in a sense. And anyway, his son came to me after that and told me what happened, and he just thanked me. Thank you so much for what you did. And I said, that's okay, you're welcome. He said, you restored my dad's dignity. He never, ever wanted to be that way. And he told everybody. This is a man who, if he didn't die on the battlefield, was never going to be kept alive this way. And so thank you very much. But that just shows you the power of a healthcare directive. And not everything needs to be enforced. Not everything comes to such extreme things. But that's kind of an extreme thing, and it worked, and the man's dignity was upheld, and had the sister or daughter removed, and there you go. And so that's how that went. So with all of these things, your trust, it helps you avoid probate, the will that goes along with it, and deals with smaller personal property, and deals with things like guardianships and that sort of thing, and your powers of attorney for financial, and your healthcare directives. You are armed with everything that may happen to you in life as best possible, and you will have your affairs in order, versus relying on the state and our governmental agencies that have a default program for you, and it's usually not very good. It's not anything that any of us wants. And so by having all of this in place, you are prepared for everything that I'm talking about. And again, I think that it's really easy for all of us to say, well, not me, I'm in good shape, I'm young, I'm in good health, that's not for me, this is for old people. It's for everybody. And as I say, at least the will, healthcare directive, and power of attorney, everybody needs that. If you have any assets and gross value of $200,000 or more, you absolutely need a trust, and you should get it, because we really do all have the same chance in life of when our time comes, which we can't predict. None of us can predict our demise. Now, that's foundational, what I'm talking about, what everybody needs. Some people need add-ons. Some people, things get a little more exotic. We have some wealth clients that have assets that are, anything of 30, 40, 50 million or more. They may have estate tax issues. They may be in jeopardy of having to pay an estate tax, which is a horrendous tax. It's 50%. It's quite brutal. And maybe they need to have their money broken up to bring their estate value down, so they're not subject to an estate tax. And that may involve things like family limited partnerships, irrevocable trusts, gifting programs, all to try to, again, bring down the taxable estate tax and minimize that exposure. Other add-ons that are a little bit more common that not even our super wealth clients need is we have clients that have rentals. We have clients, yeah, I got 5 or 6 rentals, I got 10 rentals. An LLC or plural LLCs may be a good idea for asset protection, and to isolate those and to keep them separate from your other assets in the event of an exposure, a liability exposure. Yeah, insurance is always something that's still needed. It's a first line of defense, but insurance fails. There's a lot of exclusions. I can name a bunch of them. I can tell you number one is mold. Mold's excluded, and you have a claim where there's some mold that got behind some dry board and in the shower or something, didn't even know about it, and your tenants get some exposure to a respiratory problem through the mold, the toxic mold. I've had that one happen, and insurance, no coverage. It's an exclusion. It's number one, and well, then that would open up all of the rest of your assets to liability. But if you had it in an LLC, it would contain it within this LLC and create firewalls to not bleed over into your other assets. And when I say multiple LLCs, in a perfect world, if you'd put, other than your primary home, which always belongs in your trust by itself, if you have other income properties, commercial properties, whatever it is, agricultural properties, one or more LLCs is probably a good idea and in order. And even take some, a lot of my clients have residential income properties, and they have a mix of long-term rentals and Airbnbs. And we separate those into different LLCs because Airbnbs have higher risk exposure. You have more transitory people coming in and out. There's potentially parties or whatever the case is. They just have higher risk than a single tenant that's been there for 4 years and is not doing anything. So we don't want to mix those. We'll usually separate them. I had a client who made these two LLCs to separate his. I thought his name choice of his LLCs was kind of funny. It was Long Pants and Short Pants LLC. Long pants being the long-term ones and short pants being, it's kind of funny. But anyway, so you see the need for that. And then even I have kind of a rule that's a sort of an informal rule, but it's either 5 properties or $1 million. I don't want to see more than 5 properties or $1 million in any one LLC. And if you've got more properties, then you need to get another LLC. What about a corporation? We don't want to put property in a corporation. That's just, there's tax issues with that. Corporations are for businesses. Having said that, maybe you have a business and it's either already incorporated or maybe it ought to be incorporated. Whatever the case is, all of these should be connected to the trust. Think of the trust as the center of the universe. Think of the trust like your sun, and all of the planets going around it are your assets. So everything is connected to the trust. They're like the planets that are going around. You've got an LLC, it's connected, the owner is the trust. You've got a second LLC, the owner is a trust. You've got a corporation, the owner is the trust. You have life insurance, the beneficiary should be the trust. You have a brokerage accounts, the trust. So everything is either in the trust, like your primary residence, or it's connected to the trust. And whatever the case is, with that being done, when you pass, you avoid probate. And all of those assets go to your heirs and who you want them to go to without being subject to probate. And that's important. And again, think of the cost, think of the time that it takes, think of the rigorous procedure and the public nature of that trust. All that can be avoided. And so that's really what this is. This is the purpose of my talk with you today, is to impart some information and knowledge to you. What I think, from somebody who does this all day for 27 years as the professional, what I think your lives ought to be in terms of structure. If you don't have this, you should really consider getting this structure. Maybe you aren't a person with the properties, that you don't need the LLC or LLCs or the corporation, or maybe you already have them. If you don't have the estate planning in place, you should get it in place. And if you think, again, time is on your side, maybe it is, but maybe it's not. And it's just a matter of being prepared. And how do you want to go through your lives? Do you want to be prepared or not prepared? And moreover, do you want to leave these issues to others? I have clients that will sit there and complain about probate and tell me how much they hate it and how much this is terrible and it's so expensive and why does this have to be? I don't mean to be crass, but you can blame your parents. They didn't do it. And so it's not just you all, it's the people that you're leaving behind that will have to deal with all of this stuff. Do you want to leave them an easy process? And I can tell you what that looks like. Folks come in, and it happens every day. Someone I did estate planning for, or someone who just came to me after someone else did it and they died, and just had a call. What is today? Today is Tuesday. It was yesterday. Someone had just died. Someone I'd done the estate planning for, and that person they named as trustee is, what do I do? I'm so overwhelmed. I don't know what to begin. There's a house. There's this. They got kids that are knocking on the door and blah, blah, blah. And so let's talk about this. So here's what needs to be done, and here's what we're going to be doing. And I just lay it out, and she says, that's it? That's it. Wow, that is so much easier than I thought. And I said, that's music to my ears. That's it, is what I want to hear. Whole different world if this was a probate. And we've just got to round up the assets, pay off the bills. What are we going to do with the house? Well, there are bills that need to be paid, and he did want it sold. Okay, so then let's clean out the house. Let's give the personal property to the kids. They probably should go to them. The rest of it is probably in a donatable condition or even a trash condition. Whatever the case is, let's do that. Let's hire a real estate agent. Let's get this thing on the market. Let's sell it. Let's bring everything to a point. Let's liquidate everything in a bank account. Bills are paid. Now we're in a position to distribute. Let's close it up. And the time that takes is the amount of time that trustee is able to do that, which I guarantee you is less than a year, maybe even a couple months. And so what a difference. And in terms of cost, a couple $1,000s in administrative fees on the back end. On the front end, I can tell you, because I'm pretty open and transparent with what I charge, when we're talking about people that are most people, they own a home, they've got maybe some investment accounts and a little retirement or something like that. That's most people. For a married couple, I charge $3,500 plus recording fees for deeds. For a single person, I charge $2,500, and I'm about right in the middle. You get the big expensive firms, they're going to charge $5,000 for a married couple and about $3,500 for a single. And then you got your legal Zooms of the world, which you get what you pay for in this world. I repair a lot of legal Zoom stuff, and I probate a lot of legal Zoom stuff, just so you know, or a paralegal who did this. I have a client who was supposed to get dad's house in San Diego, mom's house rather, mom's house in San Diego. It's $1 million property. And dad had a paralegal write it, the trust. And the trust says, I have one child. He actually has 2 children. And where it says the house, it says, I give the house to my children. And children are defined as biological, this, that, blah, 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 blah. No, that doesn't say you. It says children. You have a brother. Yeah, that means it goes to both of you. No, he was leaving it to me. That's why it says here, just me. Well, that's why you get what you pay for. He hired a paralegal to pay a couple bucks, and he got a couple bucks worth of confusion and ambiguity, and you don't get it. Not from what I see. It says I give it to my children. Children is defined as my biological children. He had 2 children. This goes to you and your brother. So, unfortunately, again, in life you get what you pay for. I've had people that download stuff off the internet. I'm pulling this and I'm pulling this. Well, that will that you copied from Wyoming is not going to get it done. You know? Or that piece of crap that you got from whatever that you got on the internet, that's not going to help you. And so whoever you decide to help you, have it done professionally. It's the world of difference. And if, like I say, when you take a legal Zoom, you know, my clients meet with me in person. We sign everything in person. My paralegal's a notary. We don't send you off to go find a notary and get this stuff notarized. And by the way, make sure you get deeds prepared so you can transfer your deeds, and make sure they get sent off to the recorder, and make sure you get all that paperwork right to send off to the recorder and this and that. It's going to be a bad result. We do all of that. We send it to the recorder. We do everything. It comes back to us to make sure it got done. And so just make sure you use someone professional. It's not worth, go save on something else in life. You know what I mean? But this is not one of the things to be that way. And as I say, there's lawyers of different types. I've been doing this 27 years. Again, I think that for most of my clients, they're people that are business owners and or people that own real estate, different types of real estate, and they all need the estate planning. But the practice that I have overlaps, as you can imagine here. And I'm not the guy to see for a divorce. I'm not the guy to see for a DUI. I don't do criminal. I don't do family law. I don't do personal injury. I don't do immigration. I don't do anything else. I do these 3 things, and they overlap for my clients for these reasons. Yeah, so that's what this talk was about today, to hopefully give you some information and knowledge about how you ought to structure your life. And when you actually choose to do it is up to you. I would argue that time is not on your side, again, and that you ought to have it done sooner than later. If you have children, that ought to be a motivating factor to do it. Even a wife ought to be a motivating factor. I'm one of those guys, I'm single, I get hurt. It's just me, what do I care? Don't worry about me. But when you've got other people on the line, spouses and children, take care of them. You know what I mean? And so, so I'm happy to answer any questions that you have, and provide any other information in any specific circumstances, or they're here online.
We have maybe about 15 minutes if anybody wants to ask a question or two.
Yeah.
Yeah.
I've heard that selecting trustees is one of the challenging pieces where you have to have some restrictions there, right? Like they cannot be direct family members or something like that. Can you?
Well, yeah, sure. I will tell you that selecting trustees can be challenging for some people, but for most people it's not. And I don't think that you want to get overly creative in the selection. It sounds corny, but trust and trustee go hand in hand. You should pick whoever are the most who have the best judgment and responsibility for the job. And you ought to do it for people that are closest to receiving the assets. For instance, what I mean, I have a son who's 25 and I have a daughter who's 23. I had other people as my trustees when they were younger because they had an age restriction of 25, so they couldn't be the trustee because they would just bypass that restriction, right? They just give themselves the money. So I had a girlfriend who I don't have anymore. I had a best friend who is not a friend of mine anymore. And I reached a point where I said, you know what? My son just graduated from Fresno State. My daughter's doing well. Good enough, close enough. I'm going to make them my trustees. They're the ones that are receiving my assets. They're old enough now, in my opinion, and I'm not going to put someone between them and their money. Because let me say this, trustees can get sued, and trustees don't get sued for giving too much money. Do you know why they get sued? For not giving money. For whatever reason, they're sitting on the money or they're using the money or something. That's why they get sued. And so if you can avoid putting people in between your children or the beneficiaries, that's the best thing to go. But they should be close. So if you're married, it should be the two of you as trustees. When one dies, the other is the sole trustee. And then if you have children and if they're of appropriate age, one or they should be the trustees. We do have situations, well, I have children that are young. Okay, great. Well, then maybe my brother is the trustee or my sister. Whoever is the most responsible. You don't want to pick people that are irresponsible. These are important matters. But for some people like myself, who I don't have anyone else, a natural person, I don't have a spouse, I don't have that girlfriend anymore, I don't have someone like that. For someone like me, people without children have difficulty selecting trustees. If you're not that person, your selection of trustees ought to be pretty obvious. Does that answer your question?
Yeah, I think so. I think the first thing is you can select a family member with the same last
You
name.
absolutely can and probably should.
Yeah, okay. Yeah, that's what my confusion was.
Yeah, there's nothing that says that you can't. Absolutely not.
Okay.
And you should try to do that.
Yeah, and then do they, the follow-up is a trustee, obviously if it's a direct family member, they'll do the right thing. But if you select somebody whom you trust and it didn't turn out that way, do they have, are there rules they have to follow? Like, are they free to gobble up the money?
No, they're not. It's a good question. They have, whoever serves as trustee has what's called fiduciary duties. Fiduciary obligations are the highest duties in law. They're special duties, fiduciary duties. They are, you are a person who's held in trust. And when I talk about suing trustees, I've sued many trustees that are bad actors, that are, when we finally got all the accounts and everything, we're looking at the bank account and they're off buying $200 worth of stuff at Costco for their barbecue, and they bought themselves this, they paid mortgage payments, they paid a BMW payment, this and that, and all to the exclusion of the kids that they weren't giving any money to. The evil stepmom, the evil uncle, those sorts of things. I've lit up a lot of trustees and had them removed. And so there are consequences to bad actors. You can't always eliminate that risk, but you can, at least in the beginning, pick good people. And if they should change, like the circumstances with my friend, the circumstances with my girlfriend, I changed the trustees. That's
Yeah,
what you
because
do.
it's a living trust, so as long as it's.
I can amend it, and so when those people were no longer in my life, and then when I ran out of selection of trustees because I didn't want my family members, I said my kids were good enough at 23 and 25. Yes.
Can you briefly explain the probate process? What does that look like?
Yeah. So the probate is it is initiated by the filing of a petition for probate. That starts a probate. You get a hearing about 7 or 8 weeks out to have the probate opened, and the person who's the executor or administrator, the petitioner, approved, hopefully. So that's 2 months. And let's say they're approved, then they have the all legal authority to act on behalf of the estate. And then from there, a period of 4 months called a creditor's claim period has to run. And probate can't be closed before that, and creditors are able to, people who owe or owed money from the state, submit claims and say, hey, he owed me money, I need to be paid. So that puts you 4 months there, 2 months, 4 months, that's 6 months out. Now you're at a point where you're able to move to close the estate. In between there, in addition to the creditor's claim period, there's different things like publications. You ever remember newspapers? Remember on the back of newspapers, you see all those notices. You go, what the hell is that? And remember that? Some of you don't remember, but those were those probate notices, letting creditors and people, putting them on notice that someone's died and there's an estate. And there's inventories and appraisals that have to be done to value the estate. And then there's a petition that has to be filed to close the estate, and that might be heard, at least in Fresno County, in about 6 months. But there's 12 months right there. Yes?
So, patents. If you link a patent to an LLC, I would assume you put the LLC into the trust, correct?
So patents are, I have my own position about that, and some people will differ from me. I think that, let's say you have a corporation or an LLC, let's say it's the operating company that you're doing business in. I don't ever want to see that patent owned by that company. What I want to see is individually you own that patent and you lease, you give the rights to your LLC to use that. So, but that LLC would be owned by the trust, and maybe you put the patent in its own LLC just to have it, and then that is owned by the trust for purposes if it's got value, so it doesn't get held in a probate. But if things go bad in your business, you can trash that business through bankruptcy and you still got your patent. That patent goes down the toilet with that business if you have it in the business. That's why I don't like it in the business. Does that make sense? Yeah, but somehow, some way it's connected to the trust. But I like it set up that way. Yes, sir.
Going back to trust, I heard you talk a lot about like the different customizing you can do,
Mhm.
how thorough you can be, equity stakes among siblings, and
Sure.
all that. Can charitable organizations or nonprofits be a part of the trustee that gets a portion of whatever your estate is? Or
Though they can be part of the beneficiary, they're probably not going to be the trustee.
Right.
The trustee is the manager who deals with it. But I do that all the time. I have I can't remember what they are. I just did one last week. Someone who has a love for animals, and I don't know, is it Waggles or something like that? And all the different no-kill shelters, like 4 of them. She gave $5,000 to each one of them, if that's what you mean.
Yeah.
And then not to get into this at all, because this is more exotic, but for some people, for tax benefits and reducing their income, there's a charitable remainder trust that they can give a big amount to, and it's really driven more by tax savings than it is benevolence.
So actually on that topic, so those like donor advised funds that people have, you can funnel through there to save on
They're usually standalone, separate.
Right.
Standalone. So you still have your trust, and then you have this
Okay.
charitable remainder trust. They can be embedded, but most people do them separately.
Okay.
Yeah. And there's lots of exotic things can go from there. This is really I don't want to call it basic, but essentially the basic structure that everybody needs. And then there's add-ons for all of this, depending on whether it be that or family limited partnerships, and for a lot of our ag clients and things like that.
Yeah, I wasn't aware of how customizable these seem to be.
A lot more customizable than a beneficiary designation, right?
Yeah, sounds like.
Yeah. How are we on time?
I think we have time for one more question if anyone has one, and then we should probably call it a day.
Yeah.
I have a question. So does the trustee get paid, or do we allow for money?
That's a good question. The default is that unless the trust agreement says that they're not, they are entitled to reasonable compensation. Reasonable compensation has evolved through the courts. When I first started practicing, reasonable compensation for a private trustee like your kid or your brother or something was deemed to be 1% of the entire estate. And if you were a professional trustee, there's professional trustees out there, trust companies, they are entitled to 2 or 3%. Over time, the courts have felt that it's too big of a windfall. If you think about it, like think of there's a $5 million estate or something for them to receive that. And so now courts won't allow that, and courts will only allow a reasonable rate, and that person has to keep their hours, track their hours. So maybe $45 an hour, $25 an hour, and then they have to track their time and that. But I will tell you that a lot of people, for a lot of us, myself included, my mom, her trust, my mom and my dad's trust, I was the trustee, as you can imagine, and I had 2 brothers and 2 sisters. There was 5 of us, and sold off a ranch in Easton, a ranch in Clovis, sold mom's primary residence, and closed out some accounts, brought all the money into account, distributed it, and frankly for me, like a lot of people, maybe most people, it was for my family. I didn't need any money from it. I waived my fees. But I was entitled to reasonable compensation.
Okay.
I just didn't need it or want it. I got my inheritance. I was good with that.
Yeah, I have one more question. So when you have properties and you're gonna put them into the trust,
Mm-hmm.
you go to the recorder's office, but you said that your company does that, so
Yeah.
the client doesn't have to.
Right.
What is the fee to move those houses out of the title that they're in and then putting them into the trust? Is there a fee per house?
So
How
with,
does it work?
yeah, good question. With me, it is included in our services. And I don't have there are attorneys where I've seen, well, they'll do your primary residence, and other ones they'll charge you like separately, like $200 a deed. I don't do that. It's all included within my price. The only thing that is extra is the actual recording fee. Your primary residence in Fresno County is about $25, and any non-primary residence has a $75 fee on top of it, so it's $100. So if you come in at least I can speak for myself, if you come into my place with 10 properties, I'm probably gonna have a conversation with you about LLCs, but aside from that, the 10 deeds is included within the price. You're just paying for each of the recording fees.
Got it.
So that's it. So thank you all very much, and everyone online. I appreciate your having me and letting me speak to you today, and I hope I've imparted some knowledge and information that you can take from here and think about your own lives, and some way, somehow, take some action and get these things done for your own betterment, and again, having your affairs in order.
Thank you, Paul.
Thank you.
And just to double check, best way to get a hold of you, this contact information right here?
Absolutely. This is my Fresno office. Probably not for you all, but I have an office in Irvine and San Diego as well, Southern California. So
All right.
thank you all so much.
Thank you very much, Paul.